Good morning, everyone. My name is Henry Green, and I will be presiding judge for us. Let me introduce the other judges who are here with me this morning. We have Amy F. Klein, and also we have James Burgess this morning, and they will be the judges that will hear your case this morning. Before I get started, let me announce the case. Case number 123535 in the matter of SL, a minor, EL, and JH appellees versus AL and MW appellants. I need the parties to state their appearances. Let me have the appearance for the appellee first.
For appellees, Ronald W. Nelson.
Thank you, Mr. Nelson. And for the appellants.
May it please the court, the appellants appear through Valerie Moore.
This case has been set for our 15 minutes. Ms. Moore, do you want any rebuttal, or would you like to save some of your time for rebuttal?
Yes, Your Honor. I'd like to save 3 minutes if I could.
Okay. Now, are the parties ready to begin?
Yes, Your Honor.
We are. Yes, Your Honor.
Okay, we're ready to hear your argument. And
May I proceed?
yes.
Okay. The case before us today is both simple and complex. Normally in a UCAPA action, we are dealing with two parents, a case where there's a legitimate threat that one parent will abduct the child from the United States to another country. Likewise, in a case that involves the Hague, we are normally dealing with a conflict between two parents, a case where a parent unlawfully removes a child to another country, and a parent seeks a court order returning the child. In the case before us today, we have neither of those issues. This is a case where we have a child with dual citizenship in the United States and the Netherlands, was placed in the custody and care of her aunt and uncle in the Netherlands. The power of attorney was executed by her parents for care of the child. That was unfortunately not a unique situation for this child. This child had bounced around between various states and countries throughout her life. While staying in the Netherlands, it became apparent that a return to her parents was not in the child's best interest. As such, the Dutch court in July of 2019 placed the minor child in foster care, with the placement being with her aunt and uncle, similar to a kinship care in the United States. Backing up a little bit, in 2011, stepmother had requested and was granted parental authority over the minor child from the Netherlands court. So essentially, the last order involving this child prior to the foster care placement was out of the Netherlands. In November of 2019, 5 months after the child was placed in foster care, father and stepmother filed an action in The Hague arguing that the child was unlawfully removed. After arguments were heard on that case, but before the ruling came down, stepmother filed a protection from abuse action against aunt and uncle in Johnson County, Kansas. In January of 2020, the Hague District Court ruled that the United States was the habitual residence of the minor child, but that the stay was not an unauthorized detention. Following that adverse ruling, the parents then filed a UCAPA action in Johnson County. In March of 2020, while the case in Johnson County was pending, the appeal in the appellate court of The Hague determined that there was no unlawful transfer of the minor child to the Netherlands. In addition to this finding that there was no unlawful transfer, they found that there was a serious risk to the minor child, the child was resisting return, and the child was of sufficient age and maturity that her opinion should be taken into account. The Hague court declined to return the child to the United States. And this is important because they were tasked with examining the determination of what was the habitual residence of the child, whether there was an unlawful determination, and if any exceptions existed. This is not something they took lightly. The ruling references all of the evidence that they considered when making this determination, including substantiated claims of the child's resistance to return, statements of the child's court-appointed guardian, and statements the child herself told the court, as well as the arguments from the parents and attorneys. Only once they made that decision for the non-return of the child did the Dutch district court proceed with moving to the merits of the action, ultimately culminating.
Excuse me, in your supplemental brief, this is what you were talking about on page 12 when you said the Dutch court properly weighed it, as far as the decision, as far as at the, I guess, the Hague appellate court. Is that what you're referring to?
Yes, Your Honor.
Okay. And why I asked you this question, emphasize again, why is this so important as far as this matter?
Because of comedy. When we talk about comedy and whether we should follow the rules of a foreign country or foreign jurisdiction, we have to look at whether or not they properly applied the statute and the laws. And so because they waited to get to the merits of the case and terminating the parental rights and kind of proceeding down that path, they were properly adhering to the Hague Convention as well as the Perez-Vera report when it discusses once a determination is made by the Hague court that return is not feasible or necessary, that then where the child is at can proceed with making rulings regarding the child.
Would you speak a little bit about this grave risk, one of the exceptions that they talk about? Because when I was looking at research and looking at cases, it seemed like they go every which way. Now, help me have a better understanding of that.
Sure. And I think it's important to understand that they kind of looked at several things. They looked at the serious risk of the minor would be exposed to physical or mental danger. So the Hague court made that finding that there was a serious risk that she would be exposed to physical or mental danger if she was returned or placed in an unbearable situation. Then they also looked at what was her age and maturity. Was she capable of making that decision? And they talked to her as well as her court-appointed guardian, as well as therapists and all of the facts of the case to make that determination.
Was she 13? Was she 13 at the time? I know she's 15 now.
I'd have to look at her birth date. I can't remember off the top of my head. She was either 13, almost 14, or 14. It was right in that wheelhouse, I guess I would say.
And the reason why I asked that is because it seems like some of the courts, when they were talking about asking as far as a child and maturity, they really zero in on the age. Okay, and certainly, I think they're saying some cases saying under 13 or 10, that's not acceptable. I think I've seen 13, to 15. Are saying that the child has enough maturity to express sincerely whether or not she wants to return. I'm sorry for interrupting you, but speak on that for me a little bit.
And I think that that's important because when you look at the Perez-Vera report, which kind of tells us what they were thinking when they were doing it, they could not agree on the age. That was something that they could not agree on. The convention could not come up with a perfect age, which makes sense. As we all know, a 10-year-old, some 10-year-olds are mature and other 10-year-olds are not. And so I do think it's important that we don't have an age. And so they were given the discretion, the judicial discretion to kind of look at the facts of the situation and make a determination based on that child and those particular facts. And in this case, that's what they did. They looked at that child and her specific facts, as well as talking to her court-appointed guardian. So there was also an adult. It wasn't just what the child said. That was one of the factors that the court considers, similar to when we are making decisions with respect to custody and a regular divorce action. What the child wants is certainly something the court can consider and must consider, but it's not necessarily the most persuasive thing. However, in this case, we have her specific resistance to being returned, coupled with the fact that they made a specific finding that there was a risk of serious harm upon her return. So it wasn't just that she didn't want to go, it was that there was a serious risk of harm if she returned, that there was concerns regarding the physical and emotional safety of her with her parents. So it wasn't just what she wanted, but that was something that they considered.
Thank you.
Is there any other questions I can answer?
Well, I interrupt you. You still have, I think, about 3 or 4 minutes before you get into your rebuttal time.
Certainly. I think that, this is also important to understand that in Johnson County, we didn't have an evidentiary hearing. The court didn't hear from the minor child, didn't hear from her therapist, was making a decision on this based on just the legal arguments, which to a certain respect is understandable. But to make an argument and to make a decision based on legal arguments, when we have a court that has interviewed the child, has talked to the parents, has talked and had hearings and evidence at multiple levels, made that decision, I think we need to afford that comedy.
Do you want to talk a little bit about the Silva case that we asked, to look at for us?
Sure. So the De Silva case, the mom, there was a case filed in Oklahoma. The mom then absconded to Sri Lanka, which was not a party to the Hague, got some orders there, and it looks like dad kind of acquiesced because they weren't part of the Hague. Then mom went to Canada and the child was visiting with dad, and the child stayed in Oklahoma, and dad filed something in Oklahoma. Essentially in that case, what the court said was, when we look at the Perez Vera report, specifically paragraph 30, the child's views may be conclusive. That in this instance, the court again investigated and made a determination that the child's reasoning was appropriate and found that that was conclusive. And they gave great deference to the court's ability to observe the minor child and the evidence. And so that's what I'm asking the court today to do, is give great deference to what the Netherlands did, as they had the ability to observe the minor child and the evidence.
Well, thank you. Did you have anything else?
No, I'll reserve just for rebuttal then.
I appreciate that. Now, Mr. Nelson, are you ready to proceed with your argument?
Yes, I am, Your Honors.
Okay, we're ready to hear it.
Thank you very much. As Ms. Moore indicates, this matter is simple and yet complex. The complexities in this case are not quite as stated by Ms. Moore either in her argument or in her brief. The arguments that Ms. Moore presents, in fact, turn everything upside down. The complexity in this case is not really the facts, because as the district court indicated, the vast majority of facts in this case regarding the parentage of the child, regarding what had happened that led to the child going to the Netherlands, regarding the retention of the child, other things such as that, all of those were agreed, excuse me, Your Honor, were agreed by the parties in the Netherlands, were stated by the courts in the Netherlands as agreed facts, and then were stated by the Johnson County District Court from the decisions of the Netherlands District, from the Netherlands court decisions. The complexity in this case arises from a couple of different matters. Number one is that in Kansas, in the United States, we are dealing with child custody jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act, which is subject matter jurisdiction. The Netherlands, as a different country, obviously does not have the Uniform Child Custody Jurisdiction and Enforcement Act. However, it operates under a European regimen, which all of the European countries have signed on to a particular convention that I'll get into that deals with subject matter very similar to the Uniform Child Custody Jurisdiction and Enforcement Act. A bit of complexity, a bit of language problem is that we are somewhat dealing in this case with two separate Hague conventions. The first convention that we're dealing with, and Ms. Moore spoke extensively about and briefed about and focuses on, is the Hague Abduction Convention. The second convention that the courts in the Netherlands, not the Hague court, but the juvenile courts there dealt with was the Hague Child Protection Convention, which doesn't necessarily deal with child protection matters. It is a jurisdictional convention. Additional complication is that the United States has signed that convention. President Obama signed on to that convention. It has never been ratified by the United States Senate, and so it has not gone into force between the United States and the Netherlands or the other countries that have ratified that convention. The United States and the Netherlands, as well as all of the other European countries, however, have not only signed on to, but also ratified the Hague Abduction Convention, which the Hague Court dealt with. The appellants argued that the district court in this case was wrong because it didn't give binding effect to the Hague Abduction Court's decision not to return the child to the United States. It's very, very clear, however, under the cases that the court requested that we discuss in the supplemental briefing, as well as the Kansas Supreme Court case Dalmaso, there's the other Kansas Supreme Court case that I can't remember right off the top of my head, that both speak to the fact that the Hague Abduction Convention has a very narrow focus. That narrow focus is, number one, determining where is the habitual residence of the child, what is the ordinary residence place of the child. And the Hague courts, the appellate courts in the Netherlands, decided that the United States was the habitual residence of the child. There's really no dispute about that, even though that is a legal decision. The ordinary residence of the child prior to this hullabaloo was clearly in the United States, in different states, but in the United States. The second part of this dispute is what effect to give to the Hague Abduction Court's determination that even though the United States is the habitual residence, that the court determined that there was basis for an exception of return of the child to the United States. Dalmaso, the other cases, all of the cases that are discussed in both our main brief and in the supplemental brief indicate that the Hague Abduction Convention, having that extremely narrow focus, focuses on initial return, but it focuses on the fact that the subject matter or the determination of actual custody issues, the substance of the custody issues, is always in the court of habitual residence, is always in the court where the child's ordinary residence is, and that the Hague Abduction Court's determination of any exceptions is not binding on any other court, because that would make it in effect a substantive decision of custody. When the Perez-Villa report, all of the United States Supreme Court decisions in Abbott and Manaski, the Kansas Supreme Court determinations in Dalmaso indicate that is not to be given any substance or substantial
Excuse me, let me ask you a question. Down below, the Dutch courts, and I'm referring to what the Dutch courts were doing down below, and then it got to the Hague Appellate Court. Hague Appellate Court criticized them and saying, you were basically saying that you had, that this child was an official, as far as a resident of the Netherlands. And as the Hague Appellate Court, they're saying you got this wrong. Yeah, this is not right. But one thing which you have mentioned when you look at as far as this Hague Convention, abduction convention, they do have these exceptions. It's saying that, okay, and it seems like this is what the Hague Appellate Court was doing. It's saying, no, as far as this habitual residence, it's in the United States. But however, we find these two exceptions, okay? And they do have the right to do that. Is that correct?
That absolutely correct.
Okay.
They do have that, but the determination of those exceptions to return under the Hague Abduction Convention are not substantive decisions. Those ultimate substantive decisions are left to the court that has child custody jurisdiction as the habitual residence of the child.
Okay, then counsel, that gets me to my critical issue.
Yes.
Is what is your basis for finding that Kansas is the state that has that jurisdiction?
Well, and first and foremost, we start out with the fact that all of the courts have determined that, well, with one exception, determined that the United States is the place of ordinary residence of the child.
And that may be fine, but how do you get to Kansas?
Well, how we get to Kansas is the district court set out what the where the child lived and where the parents' residence had been.
The child lived in Florida.
Well, the child lived in Florida, but the child had contacts with Kansas over.
Not since 2017. So how is there any significant evidence in Kansas about the child's lifestyle when she'd been living since 2017 in Florida? Where's the connection?
Family. And district court specifically made those factual findings, that there was a continuing substantial connection with Kansas.
Okay, right there. Tell me what that substantial connection is. I don't see it.
Well, first of all, the parents had lived in Kansas previously, 2017 and before, with the child, and the child's grandparents and other family continued to live in Kansas.
But the child has no connection. When we read our jurisdictional statute, it says the child lived in Kansas for the prior 6 months, or the child lived with at least one parent and has significant connection.
Well, and there's
no connection to the child.
But there's two other jurisdictional bases. There is number one, home state jurisdiction, which home state jurisdiction does not exist in this case because, as previously stated, the child for 6 months, for a 6-month period prior to March 2019, had lived in Florida. But that's not the only jurisdictional basis. The second is that there is a significant connection.
And you haven't explained the significant connection to me. I don't see that.
And Your Honor, the district court did that.
I'm asking you. You tell me.
I understand
your argument.
I understand. And let me go ahead with the other jurisdictional bases, because what the district court said is that there are 2 and probably 3 bases under the UCCJEA that can come. It's either significant connection, or it is vacuum jurisdiction, or it is because Kansas is an appropriate place because
there is no vacuum. The Netherlands took jurisdiction.
Netherlands could not take jurisdiction. There, in fact, going to that point, there was the Supreme Court. Well, there were the 2 as yet unpublished decisions from the Court of Appeals and from the Kansas Supreme Court within the last month and a half. That situation is very similar to if a child in need of care case is filed in Kansas, even though the child has lived in another state, or there is another contact or better contact with another state in the United States, Kansas can exercise temporary emergency jurisdiction, but that only matures into full jurisdiction where substance can be determined if nothing happens in another place that has jurisdiction or power. And in those cases that I've attached to our briefing, the Kansas Court of Appeals and Supreme Court said it is inappropriate for a trial court to go ahead when it has temporary emergency jurisdiction and just ignore what's being done or what state the child previously lived in or what connections that child has. The court must look at that and can't just take it and run with it as the Netherlands courts did. As the
You don't think Kansas did that when it ignored what the Dutch courts did?
Absolutely not, because the Dutch courts didn't have the power to do that. That is turning everything on its head, because that goes contrary to those cases that I cited and attached. That would be like saying, well, in Kansas, we have a child in need of care, and Nebraska, you say that you have child custody jurisdiction. We don't care. We're going to go ahead and do whatever we want to because we started jurisdiction and we've decided that this child needs protection. Can't do that. Can't do that under the Hague Convention. Can't do that under the UCCJEA. Can't do that under the Hague Protection Convention. And yet that is what the Netherlands district court did, is just said, we don't care what the law is. We don't care what the appellate court said. We don't care what the United States says. We're going to go ahead and issue emergency orders and then go further than that and continue to take that no matter what. That can't happen.
Counsel, isn't it disingenuous to say that the Netherlands court acted in contravention of some case going on in the United States? There wasn't a case going on in the United States. I mean, the child was voluntarily in the Netherlands with custodians that the parents had voluntarily placed her with when this arose, and that's where the case was initiated, correct?
That's where the temporary emergency orders were obtained, yes.
And there wasn't a competing case in the United States at that time, was there?
There was not. That goes back to the cases that I just talked about that are attached to the briefing. In those two cases, a child in need of care case was initiated in Kansas. Nothing else was going on in any other state.
And what did the Netherlands do wrong in determining that they had jurisdiction and in applying the exception?
Well, that's two different matters.
It is.
Because first and foremost, the Netherlands didn't do anything wrong by exercising temporary emergency jurisdiction for the protection of the child when it did. That's not the complaint about its error. Secondly, under the Hague abduction case, when the court said the United States is the habitual residence, but there is an exception, we need to protect the child at this time, which is not a substantive decision. That does not mean that because the Hague abduction court determines that there is an exception, doesn't give the courts of that country license to exercise full jurisdiction.
Are you claiming that they improperly applied or interpreted that exception?
It doesn't matter one way or the other, because, well, it depends which court Your Honor means.
The Netherlands, are you asking, or is it your position that the courts in the Netherlands improperly applied that exception?
Well, there's two different questions there too, because we're dealing with two different actions in the Netherlands, the Hague abduction court and juvenile court. The Hague abduction court, it doesn't matter one way or another whether they applied correctly or misapplied.
I'd like to know your position though. Are you saying that they misapplied that exception?
It doesn't matter. It's a non-issue because it's not, as I
under
said,
principles of comedy, wouldn't we have to respect that decision unless they misapplied the Hague Convention?
Absolutely not, because this is not a Hague abduction issue or case. That is a Hague abduction case, and the Perez-Villa report, all of the cases, all of the Kansas Supreme Court cases, all of the US Supreme Court cases say that the determination of an exception under the Hague by a Hague court has no effect on the substantive decision of a child custody jurisdiction court. It is simply,
for our argument's sake, if Kansas does not have jurisdiction, who's going to decide custody other than where the child lives?
well, the child lives in the United States. The child is in the Netherlands as a result of the refusal to return the child to the United States. It's the classic child abduction. Except
This
that
wasn't an abduction case, though. I mean, the parents voluntarily sent the child over.
this is an
Correct.
unlawful, that's incorrect. This was not an abduction of unlawfully taking the child, but this is an unlawful retention, which is an abduction. Both under UCAPA and under the Hague Abduction Convention, there are two parts to abduction. Unlawful.
And what's your cite for your position that it was an unlawful retention based on all these court orders that we have in the Netherlands?
Because it is in violation of the parent's rights to custody.
There wasn't any determination of custody in Kansas at the time that they went to the court in the Netherlands, correct?
That doesn't matter. That ignores the very purpose and point of UCAPA, of UCCJEA, of virtually every UCCJEA decision by the appellate courts in Kansas.
How so?
Because a court that doesn't have subject matter jurisdiction, as stated here, again, I'll get back to the cases that I've attached that are published and unpublished or unpublished yet, which is because a court exercises emergency jurisdiction, doesn't give it full jurisdiction, doesn't give it ongoing jurisdiction. It must terminate its jurisdiction when a case is later filed in an appropriate court. UCAPA specifically has as its purpose the filing of a case even when there is no existing child custody order in any place in order to establish an appropriate jurisdiction so that a determination can be made. It can be filed before a divorce. It can be filed before a parentage action. It is, as Professor Elrod says, who was the official reporter to the Uniform Child Abduction Prevention Act, it is a supplement to the UCCJEA in order to allow for pre-filing orders to issue to establish where jurisdiction is so that a court can make those orders to return the child to a place where that has that substance of jurisdiction. And getting a little back to one of your points is the Perez-Villa report, the Abbott case from the US Supreme Court, the Dalmaso case from the Kansas Supreme Court, all say that the point of all of this is to get back to the court or the place that has primary jurisdiction so that that court can determine all of those matters under its own laws. And it is a classic situation of abductors going to another place, seeking to assert the laws of that other place to their own advantage and to the disadvantage of the parent or parents who are seeking return of the child.
Well, you're not saying that's what happened here. I mean, they didn't go to another place. They already lived in the Netherlands. And the parents, the father and stepmother, sent the child over to the Netherlands voluntarily. They weren't seeking the protection of the Netherlands court to avoid jurisdiction in the United States.
Again, it's exactly the same thing. Unlawful retention is an abduction. And what they sought relief from the Netherlands courts on an emergency basis in order to prevent the parents to obtain return of the child back. They filed.
And then we circle back to Judge Burgess's point, which is you still have to establish jurisdiction in Kansas, right? In order to establish that it was an unlawful retention?
No.
Why not?
Because, well, it's a separate determination. Determination of where jurisdiction exists doesn't have anything to do with whether it's a lawful or unlawful retention. Jurisdiction is jurisdiction. Unlawful retention is a separate issue.
But your unlawful retention argument is based on the fact that you're claiming the Netherlands court was violating the Kansas court's order or jurisdiction.
That's a non sequitur. One doesn't have anything to do with the other. One flows from the other. The determination that there was an unlawful retention is properly made by the Kansas court because it determined it has jurisdiction. Not it determined that there was an unlawful retention, so it claimed jurisdiction. And the jurisdiction, again, the district court went through the fact finding, stated the facts for its basis of those three different kinds of jurisdiction, bases behind the jurisdictional claims. The Netherlands basically said, well, the Court of Appeals said that the United States had jurisdiction when the child originally came to the Netherlands. So we're going to change the rules. We're going to say it's February 2020 instead of March 2019. They can't do that under the Netherlands law. They can't do that under the UCCJEA. And the UCCJEA, as I've briefed, says that if another court of another place violates or disregards what is stated in the UCCJEA as the appropriate time to determine jurisdiction, the courts can ignore those determinations. It's the same under the Hague Protection Convention. They're very similar. They're slightly different in some of the nuances of modification jurisdiction, and the Hague Protection Convention doesn't include a 6-month window. It simply leaves it up to a factual determination of what is habitual residence. I think I'm probably past my time. Or if there are any other questions, Your Honors, I will take those, but otherwise I think I'm finished.
Thank you. Let me get back to Ms. Moore. You still have your 3 minutes of rebuttal.
Thank you, Your Honor. I think it's important to first, there was no unlawful retention of this child. I think that has been found at all levels other than the District Court of Johnson County. The Netherlands said specifically the Hague Court, the District Court of the Hague, no unlawful retention. The Appellate Court of the Hague, no unlawful retention. The District Court of the Zutphen, if I'm pronouncing that correctly, stated there's no unlawful retention. That has been decided. What the parents are essentially doing here is asking for a second bite at the apple because they didn't like what was said and found by the Netherlands courts. I also think it's important, and again, this is somewhat hard because we are dealing with not even the same framework of laws because we're dealing with a foreign country. But once the Hague Court made that decision and it went back to the district court, essentially what they said at that time is, now that you have ordered that the return of the child will not happen, we can take regular jurisdiction instead of emergency jurisdiction. So that is analogous to an async action. To use Mr. Nelson's example, if Nebraska said, hey, we don't want jurisdiction of this case, then Kansas can officially take jurisdiction. We just don't have that ability in this instance because the UCC JEA doesn't really apply with we're talking from Kansas to the Netherlands. Our judge couldn't just give a call up to the Netherlands and they make a decision as to who's going to take jurisdiction of this case, because it doesn't work that way when we're talking about foreign cases. Additionally, the Perez-Vera report specifically talks about how once there's a determination, then the underlying court can move to the merits of the matter. And they did. And they moved to the merits of the matter and are asking that to proceed in their action. This is a sad case. I'm not trying to minimize it. It's a sad case. We have a kid who lost her mother, who bounced around for years, has essentially been in foster care for the last 2 years. I agree. This is a sad case, but there is a court that is taking jurisdiction that has all of the pieces in place: the therapist, the school, ability to talk to the child's guardian ad litem, all of those pieces trying to help this child. And so to say, no, we need to just switch this to Kansas because the parents lived here back in 2017 and stepmother's parents live here is not grounds for taking jurisdiction of this case. We believe that it is appropriate to let the rulings in the Netherlands stand and that the court to give comity to those rulings.
Thank you very much for both of your arguments. We will take this case under consideration and try to get an opinion out to you as soon as possible, because we know how important this is. Thank you.